दर्शकों, स्वागत है आपका अपना चैनल कानूनी चर्चा पे। जैसे आप जानते हैं, आपने मेरा पिछला एपिसोड देखा होगा जिसमें हमने चर्चा की थी जी म्यूचुअल डाइवोर्स पे। तो मैंने म्यूचुअल डाइवोर्स की डिटेल के बारे में बताया था आपको कि पहले एक जॉइंट पिटीशन पार्टीज करती हैं, ऑब्वियसली हस्बैंड एंड वाइफ, और वो म्यूचुअल कंसेंट देती हैं। फर्स्ट मोशन होता है उस पर जज साहब के पास, डिस्ट्रिक्ट जज के पास, और फैमिली कोर्ट आजकल कॉन्स्टिट्यूट हो चुकी हैं। तो उसमें एक जॉइंट पिटीशन हस्बैंड एंड वाइफ देते हैं फॉर सीकिंग डाइवोर्स फॉर बाय वे ऑफ म्यूचुअल कंसेंट। तो विद इन 1 ईयर उसकी रिक्वायरमेंट है, दे शुड हैव बीन अर्लियर सेपरेट लिविंग। After that, after first motion, the cooling period is 6 months to wait for second motion. Then after 6 months, the another motion, second motion is to be filed by the parties. The time period, outer time period, I have already talked that it is 18 months. Within 18 months, initial period is this 6 months, within 6 months, and up to 18 months, parties has a right to file second motion seeking divorce by mutual consent. This is second motion. Afterwards, the court has to record its finding satisfaction that there is a subsistence of marriage, and whatsoever is referred in the pleadings of the petition is true, truthful, and after recording, the court has to pass, district court, family court has to pass the decree of divorce by mutual consent under section 3B of Hindu Marriage Act 1955. Now, I have referred earlier that there was a judgment, 2 judgments. I have referred, one was 2010 when in that judgment, what is contained, it is titled as Monish Goel versus Rohini, AIR 2010 Supreme Court. Article 142 of Constitution of India talks about inherent jurisdiction of the Supreme Court of India. By invoking inherent jurisdiction under this article, Supreme Court of India, in extreme cases where the parties are suffering from extreme hardship, there are daggers drawn, they are suffering with agony, and if they are allowed, they are forced to continue the marital relations, they would suffer mentally, physically, or otherwise. By taking into all these facts and circumstances, which I have referred earlier, to Supreme Court divorce ग्रांट करता था इनहेरेंट jurisdiction एक्सरसाइज करते हुए, ये मैंने जो जजमेंट रेफर की इसमें। लेकिन आफ्टरवर्ड्स द सुप्रीम कोर्ट हैज चेंज्ड एंड in year 2017, in a judgment, Amardeep Singh versus Harveen Kaur, what Supreme Court has decided that in the similar situated circumstances, facts, if the parties are already at daggers drawn, the parties are suffering with agony, if they are allowed to continue with the marital relations, and they are on these grounds, the Supreme Court has decided that trial court, even family court, even district court, which is hearing this petition, the divorce petition by mutual consent under section 13B can waive off the period of 6 months. This 6 months, but simultaneously it is required that it should also be considered while doing so that there should not be anything left over for further litigation between the parties. There should not be multiple litigation. If in haste divorce by mutual consent is given, the court should say by the permanent alimony, if parties are entitled, if wife is entitled, permanent alimony, custody of the children and other whatsoever regarding properties, joint property, other property, there should be a final disposal. With regard to all this, while considering all these circumstances, facts, this trial court also can, family court can also waive off the period of 6 months which is given, and after filing of the petition, first motion, and waiting for 1 week, another motion, second motion can be filed, and decree can be granted on that basis. This is with regard to this waiving of the period. One more judgment was there, and that is one. There is Shrestha Devi versus Om Prakash, and one is that this judgment of Shrestha Devi and Om Prakash is referred in AIR 1992 Supreme Court, page 1904. And another judgment subsequently given by the Supreme Court of India is available in AR 2011 Supreme Court 1637 is the page. Hitesh Bhatnagar versus Deepa Bhatnagar. In these judgments, Supreme Court has held that the parties who applies by way of first motion for divorce by mutual consent is at liberty to withdraw their consent, and if consent is withdrawn by either of the party during a period after or even after filing of the, obviously after filing of the first motion, and in between 6 to waiting cooling period up to 18 period. The court has gone to the extent that before passing of the decree, either of the party can either of the party or both the parties can withdraw their consent for mutual divorce, and under these circumstances, what the court has to do? The trial court has to dismiss the petition because parties are not ready to have the second motion. When there is no second motion, after this cooling period, in between the cooling, after this cooling period, obviously of 6 months and up to 18 months, this is the outer period provided under this section 13B subsection 2 of Hindu Marriage Act. In that, in trial court, in exercise of the jurisdiction under the relevant provisions I have referred, 13B of Hindu Marriage Act, can dismiss the petition. It means what is needed? What is needed? Primary is that the consent should continue. Consent should continue till the passing of the decree. Both the parties should agree and continue with their consent so that there should be a decree of divorce by mutual consent. Now in recent judgment, I will refer here, which has come on the 1st May 2023. This is what I have referred the judgments earlier. These are regarding this waiving of the period of 6 months for filing second motion, and one more ground Supreme Court has taken into consideration, that is irretrievable breakdown of marriage. This with regard to 6 months, babying of 6 months, the Supreme Court has reiterated its earlier judgments, which I have referred here. This Rishna Devi and this Atesh Bhatnagar with regard to babying of the period of 6 months. And this now with regard to this irretrievable breakdown of the marriage, Supreme Court has also reiterated that the Article 142 of Constitution of India, inherent jurisdiction of the Supreme Court, can be invoked for declaring the marriage as marriage which is not sustainable, which is not now can be continued. The circumstances are the similar, which I referred here. If party is facing hardship in continuing the relation, if they are suffering with agony, they cannot carry forward the marital ties. No doubt, this irretrievable breakdown is not being recognized or included in the section 13 of Hindu Marriage Act. The grounds of the section 13, I have already discussed in my earlier this episode. It talks about the grounds of for grant of for seeking the divorce or for grant of divorce by the district court, by the family court. Irretrievable breakdown is not recognized, is not included by the legislation. Law Commission, the Supreme Court has written to Law Commission, and Law Commission has on many occasions has recommended for addition of this ground, irretrievable breakdown of marriage, as a ground for seeking divorce, for granting divorce by the ordinary court of law, by the district judge. But it is not yet acceptable. So under these, when there is no ground for divorce, obviously the district court or the family court cannot exercise any his jurisdiction for grant of divorce on this ground. However, the Supreme Court of India has a inherent power under 142. I am repeating this article again and again in order to show that the Supreme Court has a vast power. There is for doing justice, complete justice, where there is a irretrievable breakdown of in order to give a relief to the parties to continue with their life, with the new life after having this resolution of their marriage, which they are not able to carry forward. They are not able to carry, and that the jurisdiction, these are in a recent judgment, this Shilpa Salesh and Srinivasan, I have referred first. This is a 1st May 2000. This is a 5 judges bench judgment. I have referred the question. Main consideration is that no doubt, under Hindu Marriage Act, the marriage should continue. There should be a reconciliation. There should be the whole act contains a reference, contains provision, this Hindu Marriage Act, that the court should make endeavors to have reconciliation between the two, to have subsistence of the marital relation, marital ties to carry forward. हमें तो कहते हैं, जहाँ पे जो आपको मालूम है, हमारा जो हिंदू जो मैरिज है, इट इज अ सैक्रेमेंट. कहते हैं कि ये 7 जन्मों का रिश्ता है। तो लेकिन रिश्ता आज जो लॉ इवॉल्व हो रहा है, सोसाइटी इवॉल्व हो रही है, इसमें ये कॉन्स्टिट्यूशनल मैंडेट्स आ रहे हैं कि कॉन्स्टिट्यूशन लाइफ भी कंफर्टेबल होने चाहिए, डिग्निफाइड हो गया। अगर कपल्स आर बेगर्स डांस, हाउ दे कैन कैरी फॉरवर्ड? दे शुड नॉट कैरी द बैगेज कि अपने पे लादे हैं और आप टकराव में हैं, कुछ नहीं, बहुत सारा है। तो इन हालात में तो कॉन्स्टिट्यूशनल कोर्ट है, सुप्रीम कोर्ट ऑफ इंडिया, तो उन्होंने ये भी देखना है, आर्टिकल 21 की बात करते हैं कि भाई लाइफ जो है डिग्निफाइड होनी चाहिए, कोई बर्डन नहीं होना चाहिए लाइफ में। तो इन सर्कमस्टांस में सुप्रीम कोर्ट ये पावर, जो मैंने ये जजमेंट्स दो रेफर कर दी, और भी जजमेंट जो रिसेंट लॉ था, इर्रेट्रेबल ब्रेकडाउन ऑफ और वेविंग ऑफ द पीरियड ऑफ 6 मंथ, हमारा यही रिजॉल्व है कि जो मैं ये बता रहा हूँ, ये मैं डीप एक्सरसाइज की है, मैंने इस पर रिसर्च करके प्रोविजंस और रेलेवेंट जजमेंट्स पढ़ के ये मैंने जो 2 चीजें आज जो बात की है, दिस इज कंसर्न विद द डाइवोर्स सेक्शन 13 एंड 13B। भी हम थोड़ी आगे चर्चा करेंगे नेक्स्ट एपिसोड में। तो मुझे इजाजत दीजिए दर्शकों, मैं यही कहूँगा, ये फ्री ऑफ कॉस्ट मेरा चैनल है और इसको सब्सक्राइब करो। और मैं चाहता हूं कि ये जो नॉलेज है मेरे पास में, आई वांट्स टू एक्सचेंज एंड इंटरेक्ट विद यू, और ये नॉलेज जो बच्चे हैं जो लॉ कॉलेजेस में हैं इसका फ़ायदा लें, और जो हमारे जजेस हैं, लॉयर्स हैं, और जो भी लॉ यूनिवर्सिटी के टीचर्स हैं, तो मैं कहता हूं कि ये एक मेरा इंटरेक्शन सेक्शन समझ लो, जैसा भी है। तो इसको देखो, अगर आपको पसंद आया तो इसको सब्सक्राइब करो, लाइक करो और लोगों में शेयर करो। थैंक यू वेरी मच, नमस्कार। तो अगले एपिसोड तक मुझे दीजिए इजाजत। थैंक यू वेरी मच।